Civil asset forfeiture is a legal tool that gives U.S. law enforcement authorities the power to seize property and money suspected of being related to a crime. Originally, it was seen as a way for police to target drug trafficking and money laundering rings. But law enforcement agencies across the United States now face growing criticism over allegations of widespread abuse of the practice. We begin with this report from CCTV's Hendrik Sybrandy in Denver.
In Colorado recently, a medical marijuana patient was cited for having many more plants than state law allowed. Officers suspected he was involved in an illegal marijuana operation. They promptly confiscated a lot of his personal property.
Flat screen TVs, it was jewelry, nice watches. He had a lot of money in gold and silver coins.
The seizing of property happens every day in America.
Someone doesn't even need to be charged with a crime in order to have their houses, cars, or money taken from them by the government.
Need one! In many of these civil cases, there simply needs to be a preponderance of evidence that a crime occurred, not proof beyond a reasonable doubt, as in the U.S. criminal justice system. The goal of these actions, to ensure crime doesn't pay.
The public policy that underlies civil asset forfeiture is to make sure that criminals don't profit from the criminal activity.
But attorneys like Nick Gieman claim civil forfeiture has led to a blizzard of abuse by law enforcement over the years, that police and federal agents profit greatly from these activities.
It's a huge, huge industry. Just a few years ago, the Department of Justice's asset forfeiture fund was over $1 billion, $1 billion with a B.
It's not the government simply swooping in and taking property and saying now it's ours.
Colorado's Jefferson and Gilpin County District Attorney Peter Weir says, although money seized does help fund agencies like his, he always strives to connect seized assets to criminal activity.
This is, I believe, an appropriate tool to be used in a responsible fashion by law enforcement.
Those are my cuts.
Gieman, on the other hand, says it's become far too easy for police to haul away property. His plant-growing client was a professional poker player, which explains all the cash he had lying around.
The country.
Gieman argues the civil forfeiture system is ripe for abuse.
They're trying to make it so that crime doesn't pay, but it's just been corrupted and perverted beyond all recognition at this point.
Weir calls that a cynical view, but admits
there is a possibility for abuse, no question about that.
4 U.S. states now require criminal convictions before civil forfeiture can happen. Gieman, using a poker analogy, says the deck is still stacked against ordinary Americans most everywhere else.
All of the power is on one side of the table.
A point on which both sides of the debate disagree. Hendrik Sybrandy, CCTV, Denver.
Joining us now from Kansas City, Missouri is Epan Fampi. He's the founder and executive director of Americans for Forfeiture Reform. Here with us in our Washington, D.C. studio is Stefan Casella. As a federal prosecutor, he was one of the U.S. government's leading experts on asset forfeiture and money laundering for over 30 years. And from New York, we're joined by Richard Bestrong. He is the CEO of Frontline Anti-Bribery. Bestrong served 18 months in federal prison after pleading guilty to one count of conspiracy to violate the Foreign Corrupt Practices Act. Gentlemen, thanks to all of you for joining us. Stefan, let's start in the studio. As we heard in that report, the intention is laudable. You know, people should not profit from crime. Crime should not be seen to pay. But how does asset forfeiture work in a practical way?
Well, first, it's important to understand that there are two ways in which the government can do forfeiture. One is as part of the defendant's sentence in a criminal case. If he's convicted of whether it be drug trafficking, child pornography, human trafficking, terrorist financing, whatever it might be, there's a second phase of the trial in which the property that's derived from or used to commit that crime can be forfeited. So that's criminal forfeiture. And then if a criminal prosecution is not practical or impossible or not advisable for any reason, then the government has the alternative of doing the forfeiture civilly. And it's civil forfeiture that in your first piece the reporter was addressing. In an ordinary year, about half of forfeitures are done criminally and about half are civil. And it's important to understand that the civil cases are an absolutely essential part of law enforcement, because sometimes the defendant is dead, or he's a fugitive, or he's incapable of being prosecuted because he's incompetent, or maybe the property is derived from a crime that was committed abroad and we can't reach the person, or maybe we can't identify who the wrongdoer is, or maybe just in the interests of justice, there's no reason to bring a criminal prosecution and that the interests of justice are better served by bringing the case civilly. So in a civil case, The process starts with a seizure of the property, but that's not the end of the case. I mean, seizure is to forfeiture in a civil case as arrest is to conviction in a criminal case. The seizure just starts the process. At that point, the government has to give notice or begin the proceeding within 60 or 90 days, depending on who seized the property. At that point,
Right, but in the civil instance, isn't the legal process being bypassed here? Because there is no court order that orders law enforcement authorities to go and seize the assets of someone who's suspected of a crime.
Well, in most cases, there is a warrant. In most cases, if it's a bank account, for example, that would almost always be seized pursuant to a warrant. We don't seize houses. They would just be restrained. The kinds of property that it would be seized based on probable cause alone would be cash or automobiles or things that are highly mobile. In the same way that you might arrest someone who you just saw rob the bank, but you don't go get a warrant for his arrest, you arrest him and make sure he's taken to jail, and then you begin the process. And the process begins with the seizure, but then it goes beyond that. There's notice sent to the property owner of his right to contest. 80% of the time, no one contests a civil forfeiture. 80% of the time, the property is forfeited by default. The property owner gets his notice and decides to let the property go. In the 20% of cases that are contested, the person has a right to a jury trial. He has a right to suppression of evidence. He has a right to have his attorney's fees reimbursed if he prevails.
Okay, let's go to Epen. Epen, you don't think that this program works in its current form. Why not?
Well, there's a number of reasons. Number one, civil forfeiture is a very expansive and very powerful tool, and it's prone to abuse. It allows federal prosecutors to overreach, to invent reasons to enforce laws that Congress hasn't really asked them to pursue in certain manners. And it allows great independence by the executive branch. You know, we have a system of government where people elect representatives. Those representatives are supposed to be in charge of the money, of the taxpayers' money. With civil forfeiture, you have law enforcement, you have executive branch agencies essentially running their own game, creating their own revenues. And with that incentive structure, you often see cases of abuse. And it's also important to note that even if there was no abuse on the due process or the simple notion of prosecutorial overreach, there's still a very significant problem where you have the executive branch essentially creating policy and setting its own practices pursuant to the revenue incentives it sees in the enforcement of any law.
Okay, let me just clarify this with you. You don't want to see the program disappear. You want to see it reformed.
We want to, you know, I advocate for the abolition of civil forfeiture and the reformation of criminal forfeiture pursuant to fundamental principles of due process and property rights. I think it is appropriate to have some version of criminal forfeiture as part of a sentencing process. But this notion of generally separating the property from the criminal process is really an obscure and esoteric area of the law that has its roots from maritime law, where, you know, Mr. Casella talks about, you know, having a mechanism to seize property when the property owner is dead or unavailable or a fugitive. You know, that's really a very specific area of law that you know, comes to us from the days and times in which there were pirates, literally pirates, and you couldn't obtain jurisdiction over them in any form. You know, now with international law enforcement and cooperation between nations, you know, those mechanisms are really unnecessary. Right,
okay. Let's go to Richard in New York. Richard, you were on the receiving end of this program, if I could put it that way. You were involved in defense sales. You were put into prison because you violated U.S. law, and then you worked in a covert capacity. Just take us through that. I mean, how did you end up breaking the law in the first place?
So I worked in the field of international sales as a sales executive for 10 years. I traveled 250 days a year on average. And the primary customer base for me were public officials, Ministry of Interior and Ministry of Defense. These are people that are covered as a foreign official under the FCPA. 10 years later, as part of a United Nations Procurement Task Force investigation, where the findings of a investigation with respect to contract fraud were shared by the Procurement Task Force with the Department of Justice, in 2007, I became the target of a United States Department of Justice FCPA criminal probe.
When you say FCPA, what exactly is that, and how did you contravene the provisions in that?
So it's, in civilian terms, it's bribing a foreign official to win or retain a contract. So in my case, for example, no, please.
That is not unusual in defense sales. If we read about some other countries that produce weapons, they're very often bribing officials in countries to buy their weapons. I'm not saying it's right, I'm saying that it's very common.
Well, I think that's part of the distortion. Certainly one of the ways, reasons why I rationalize my own behavior as somehow thinking of it as part of the norm of this is how things get done around here. But in fact, I knew it was illegal at the time that I did it.
So you were charged, you served time. How did you end up in your role as a covert agent, if I could put it that way?
So I knew that I was in significant trouble when my lawyer received that call in 2007 from the Department of Justice. And I was offered an opportunity to cooperate with federal law enforcement, potentially as a way of mitigating the consequences of my conduct, and also as part of the plea bargain process.
Stefan, talking about the asset forfeiture process, and you mentioned there's a civil and there's a criminal, there have been some cases, which I guess were pretty egregious cases, where the forfeiture was seen as abuse. You probably heard of these cases of a student who was traveling in his car, had $11,000 in cash, had that taken away from him. He was suspected of being involved in drugs, subsequently found that he wasn't being involved in drugs, took him a long time to get his money back. That's just one case. There are many of those, and these are the cases that catch the public imagination, and that leads to charges of police abuse.
Well, that's right. I mean, the key point that you just made is that these are the cases that capture the public imagination, but it's important to understand that the forfeitures, even in drug cases, are a small part of the overall use of the forfeiture program. I mean, Eben is concerned about the use of forfeiture in drug cases, but he's hoeing a rather small row in a very large garden. In 2014, drug cases comprised only 18.5% of all the forfeitures, and the numbers have gone down since then. And the numbers of cases that involve the seizure of $11,000 from a student are a minuscule portion of the drug cases, because the drug cases include the hundreds of thousands of dollars seized at airports and taken from the cartels and money laundering cases. The vast majority of our forfeitures these days are in the white-collar area. We use civil forfeiture and criminal forfeiture in insider trading, investment fraud, trading with the enemy, recovering cultural property, recovering property under the Endangered Species Act. I mean, that's where the vast majority of forfeitures are. In 1 year, we took $2.2 billion in the Bernie Madoff case. And it had to be done as a civil forfeiture because the defendant in that particular aspect of the case was deceased. I mean, there's no way in which, a lot of my colleagues are very good prosecutors, but you can't prosecute a dead guy. And if the defendant is deceased, the only way to get the money back and get it to the victims is through civil forfeiture. The vast majority of forfeitures that we do in federal practice involve victims, and the forfeiture is the best way of getting the money back to the victim. I don't think that the cases that involve the police stopping a student with $11,000 are abuses. I do think they might be considered to be misuses of federal resources. Should we really?
There is the other question, of course, of motivation, because as we pointed out at the outset of the program, is this profiting from this? Are police profiting? I mean, where are these funds going?
Well, the money goes into an assets forfeiture fund set up by Congress, and then the first priority of disbursements from that fund is the victims. So there's no incentive in the case that it involves victims for the police to take the money for their own benefit, because the victims are going to get the money first. The police do share in what money is available after victims are taken care of, after the expenses of the program are retired, and so forth. And that is supposed to be put to law enforcement use, and it is. And does it create an incentive? Yes, it does. And if it were up to me, I would limit the number of cases that involve small seizures of the kind you point out, just because they create a perception problem. But I don't think it's abusive because, as I said, 80% of them are uncontested. And that's because, you know, a notice goes out to the property owner. We seized $11,000 wrapped in rubber bands, a kilo of cocaine, and a loaded handgun. Do you want to contest this forfeiture? And 80% of the time that they don't. Those that are contested, I mean, if the young man got his property back, I guess the system worked. But there's a process. As I said before, there's a right to go to court, there's a right to a trial, there's a right to have your attorney's fees compensated. But in the vast majority of cases, we're talking about other things. We're talking about corrupt African dictators who put their money in the United States. I did a case involving a 747 flight simulator being exported to Iran. I don't know why it was being exported to Iran, but I could think of no good reason why it should go there. But I had no way of finding out who the criminal was who was causing the exportation. I just was able to stop the export as it occurred at the port of Baltimore and bring a forfeiture action to make sure it didn't take place.
Right, and so in that case, you confiscated the assets of the person who'd sent that.
We confiscated the thing being exported, which was the flight simulator.